Representative Henderson. Representative Larson. Representative Sherwood. Representative Stiff.
Here.
Representative Walters.
Here.
Representative Swanitzer.
Here.
Chairman Nicholas.
Henderson here.
Henderson here.
If you have a copy of the amendment stapled to the back of it. Okay, I guess, and then you have a fiscal note on this bill. Okay, so if you flip back to the fiscal note, you can see that the program cost for this exemption of $50,000 exemption, it'll cost 35 million a year. So the amendment initially was to backfill 70 million. Okay. But that got it, the amendment, it got amended in committee, so it's 40 million, and you can see that on the amendment, Mr. Chairman. And the other part of the amendment doesn't really apply, it repeals in 2025, so 2-year program to give some relief, $500 to every person in that class, right? Well, it's a residential private, let me just, yeah. It's just for homeowner exemption for a family dwelling. So it's pretty specific for a resident of the state of 5 years or longer. And $50,000 not to exceed 25% of the total fair market value. So if you have $100,000 fair market value house, the most you could get was a $25,000 exemption. If you have $1 million home, you're going to get the 50,000, which is of course 5%. So 50,000 not to exceed 25%. That's on page 2. That's the bill. But as far as the appropriation, what you're dealing with, Mr. Chairman, costs 35 million a year. We funded 40 million for 2 years. We only paid 20 million.
Mr. Chairman, so Chairman Horton, on that, I was looking, so this isn't just residential. When we say residential, that can also mean in, like I think it talks about if you're, that can be a farm or ranch dwelling, as long as that's your residence.
Mr. Chairman, it can only, yeah, and it talks about that, Mr. Chairman, but it's a residential property. It's not commercial or anything else that's in that class. It's just, and it's not a person who has 10 homes or something and has a bunch of investment properties. It's for your one residential family dwelling, one family.
So then follow up, Mr. Chairman, then I just, as I understand this, so then what we're telling, so what we're doing here is because property tax collected goes to school and counties divided up. And a lot of that property tax is paid for by industry. Boom. But then we're telling the residential homeowners that we're going to make the extraction industry, for the most part, who pays sales, severance, and royalties, backfill what the counties would have lost. So it'll come out of our general fund to fund these other programs. So we take about a $40 million hit on the general fund to make sure that people can have this deduction on their property tax that goes to pay for schools and other services in the county.
Mr. Chairman, the bill had no appropriation. It was just going to be a hit to local government. And the committee amended it. The amendment initially had 70 million to be a full pay for out of the general fund to locals, because we're making this policy and it's really cutting the locals' revenue streams. And so we were going to backfill and pay for it. And then that got amended to say, well, the locals should have a little skin in this. And we'll just do kind of a 2/3, 1/3. And that's how this came up to 40 million instead of the 70 million.
So explain the 2/3, 1/3.
Well, Mr. Chairman, so just the discussion in the committee was that it shouldn't be a total state pay for. The locals can help pay for a little bit too.
So will that be, so the 1/3 then, how, so then the 1/3 locals? Hey, Mr. Chairman, I'm sorry, it's getting late. So what, because some of that comes directly to community colleges, right? Or school districts, so they're just gonna have to absorb that reduction.
Right, Mr. Chairman, correct, and it's actually more than a third, I guess, 40, 40 out of 70 million, it's a little more than a third, I don't know, this Little League mass, probably 37, 8%, something like
Sure.
that, 36, I don't know.
Well, and so, in all practicality, once we do this for 2 years, 20 million a year, is that right?
It costs, there's gonna be, it costs the locals 35 million a year, but we are gonna reimburse them 20 million a year.
But so the idea that we'll be able to then not reimburse them 2 years, 3 years from now, is not very great.
Mr. Chairman, the program ends in 2 years, time limited, and that's on the amendment as well, ends December 31st, 2025.
Further questions? Go ahead, Representative Henderson.
Thank you, Mr. Chairman. I'm just curious, were there any locals at the committee that testified, offered their perspective?
Mr. Chairman, no.
So, Mr. Chairman, there's a bill on the Senate side, isn't that correct? Or that's a little bit larger than this?
Mr. Chairman, I haven't looked at all the Senate files. I think there's a Senate file to reduce the percentage rate, on residential and all other property from 9.5. I heard it was 7.5, now I've heard it's 8.5. I really haven't looked. I've been just looking at house bills and budgets. So, but that's a different issue. That's
So
the
have
assessment
you
rate.
done a calculation on what the average home, say 250,000 or 500,000? Average homeowner, their property tax rebate would be?
On this exemption? Well, if you figure, our effective tax rate for homes is about 0.6%. So you took 0.006, I think, times 50,000. It's gonna be $300 or so. Break on the property taxes.
Okay, any further questions
I think that's right.
to the committee? Any more questions? Public comment? Any public comment on the re-referral? Seeing none, we'll close public comment. Discussion on the bill. Move
Second,
reluctantly move do pass.
second,
Second by Representative Stiff. Any discussion? Question, roll call please.
Representative Henderson,
Aye.
Representative Larson,
Aye.
Representative Sherwood. No. Representative Stiff,
aye.
Representative Walters, Representative Swanitzer,
Aye.
Chairman Nicholas.
No. Okay, now we'll go back to 105. Where were we? 8 hours ago, roughly. So we're in the middle of public comment, aren't we?
That is correct, Mr. Chairman. I think it was about 2:03 is where I remember us being at, so.
Yeah. So let me find my bill. I think I left here in a hurry.
Mr. Chairman,
Go ahead.
so Representative Haroldson, just a kind of an overarching discussion. So from my point of view, if the government's going to create any gun-free zones, it should also provide security in that zone. But it seems like your bill goes further and says that really there should just be gun-free zones. Is there anywhere where you believe there should not be a gun-free zone? I guess that's my question. Sports stadium, courthouse, courtroom, anything at all? Or should every place be a place where you can conceal carry if you have a concealed carry permit?
Mr. Chairman. So thank you very much, Representative Stith. So an area, and I was told this did not open that up, would be correctional facilities and areas like that. Obviously, I go into those as a pastor on a regular basis. That'd be a really bad place because that is a very much a lockdown with security. There are guns in those places, but they're in the hands of a guard. But definitely that would be a place that would be out. And at the end of the day, areas that have opened up widespread, the elimination of gun-free zones, Montana being one of them, that was passed just a couple of years back. And there's others that have had these in effect for decades now, have not seen mass shootings. They've not seen issues. It's proving itself out that guns in the hands of civilians does not automatically create gun violence. In fact, it's quite the opposite. We're seeing gun violence drop. And so to answer that question, no, I believe that opening it up is an intelligent idea. Now, at the same time, if this body does so wish to put sideboards on that's the prerogative of the body. But I brought in all the horses into the race so we can have a conversation about all the horses, to use the term of this committee. So.
Go ahead.
Representative Harrelson, we talked about some of that language on page 4, and I know you went and found it, and I just didn't have the chance. We didn't have the chance to talk. Maybe you could share that with us.
Mr. Chairman and Representative Larson. So I did talk with Matt Olbrich about this, and I said, why was this language put in here? And the language would be on line 14, 15, 16, 17, where it says legislature of the state of Wyoming and no state agency or entity. And that was exactly what I assumed. He says that's so that he says if we don't have that in there, then any agency or entity at that point inside the state could make laws that would contradict this. And so they put that into effect. That's what Matt told me.
So, Mr. Chairman, as I studied that, Representative Harrelson, a little bit, that was kind of the conclusion I'd come to in going back. So this says an agency of the state or entity of the state is pretty specific. And so you point out in it, maybe I'm just asking for clarification. So on 16, that reference in 15.1, that's cities and towns. And then 21 is schools and 23 is game and fish. And in cities and towns, it's just kind of, except for in a riot type of a situation. And schools it allows for them to determine how their employees. We talked about that a little earlier, and then game and fish is otherwise, but it doesn't say anything, it doesn't say anything about corrections. There's nothing. And so where do I find that? Because as an agency of the state to restrict that, is it someplace else?
Mr. Chairman, I'm in the process of looking. I did tell them specifically that corrections needed to be exempted, and I thought for sure I saw it in there.
Well, then I apologize.
No, you're fine. Because I need to make sure and find that. I'm just looking for where it says, because that was a question I had specifically of LSO because of my concern. Is there someone behind me that knows where it's at that I'm not finding it? Mr. Chairman and Representative Larson, I do know that that is something that is very clearly stated in our concealed carry permit as well as in the right to carry as well. So a constitution carry. So I know that that would be, and that might have been where that is, because I know that would prescribe this or just be talked about in this case. And that might have been where they said that it was covered because they told me it was covered.
So I'm curious, if it's a public hospital, they have the right to, or, in other words, a county hospital. Do they have the rights to control or set requirements under this bill?
Mr. Chairman, no, that they would not, if it's a publicly owned hospital. Except for the state hospital. And they told me that was excluded because it is considered a correctional facility.
Any further questions? Any other public comment that we have not heard? Okay, we'll close public comment. We have a motion on the bill.
Mr. Chairman,
Go ahead.
let's see, I would move the bill. Do not pass. Well, let's see. I think I would like to amend.
This is a direct referral, right?
Yeah.
Can we still do that?
Okay, I will move, do not pass.
Move the second. Do not pass. Any discussion?
Mr. Chairman, hopefully I'm doing this correctly. I would like to I would like to amend the bill. And just say, while I don't believe that gun-free zones keep us safe, I think that they create a false sense of security. I do believe very strongly in promoting gun safety and proficiency in that area, including, I think hunter safety should be taught in our schools. But so because of those reasons, I would like to amend this bill with substitute X.
Move the second to submit, modify or amend under a do not pass motion, substitute X. You have a copy of substitute X?
Mr. Chairman, if you don't mind me looking, I've never heard of substitute X, so if you don't mind me.
Representative Walters, you're gonna just kind of briefly walk us through substitute X.
I just, if not, I was going to give him time to study that. So Jeremy, it sounds like we got to, today's the deadline, right?
Yeah, something has to come out today.
Yeah. Okay.
Yep,
Just
today's the deadline. I just was looking at what.
Okay. What, maybe while she's trying to study it, can
Yeah, that was gonna have.
tell me
Representative
what
Walters
the
kind of walk
difference,
through.
what the differences are here?
Mr. Chairman, one of the big differences is to carry it in a lot of these places, you'll have to have written permission, such as at the university, at a athletics facility, but also that concealed carry, to do that, it will be an advanced concealed carry permit will be created in this bill, requiring actual training more than just 21 years of age and passing a background check. So that's really the big things it does. And then but it still allows to go into these places with some exceptions, such as I said, college arenas and things of that nature. That's the quick summary of the changes.
Mr. Chairman,
Go ahead.
and so substitute X would it prevent concealed carry at War Memorial Stadium? Is that one of the exceptions, for example?
Actually, it is specifically called out. If you go to page 5, section B, and then Romanet I. So certain collegiate activities are still called out specifically.
Mr. Chairman, if you don't mind me asking so in this, under this, so let's say I were to go to Laramie with my daughter for her violin lesson and I were to be concealed carrying my firearm, I could not carry that firearm anywhere near or on the campus property without first getting a 24-hour window approval with this advanced or this enhanced concealed carry. Is that correct by this bill? Okay.
So, Mr. Chairman, I guess the question I had, so if I were traveling through Laramie and unaware of this and stopped on campus and stayed at the motel that's right next to the stadium and stuff. And, next morning I'm walking over there and I have a concealed weapon permit from another state. I'm in violation because I haven't notified the university before I do that.
Correct.
I think that's what it said. And then it has specific restrictions that even in that situation, that certain events like a arena, auditorium, swimming pool, that enhanced permit, it's not sufficient, even with noise.
Mr. Chairman, so also I'm seeing on here, so enhanced permits are through the Attorney General, not through the Sheriff's Department? Okay.
Is there such, Mr. Chairman, Jeremy, is there such a thing as an enhanced permit?
That
This creates an enhanced permit?
Okay. Further questions? Question on the amendment?
Question on the amendment, excuse me.
All those in favor of the amendment, say aye.
Aye.
Aye. Those opposed?
No.
Motion passes. Now, back to the bill. As amended, on a do not pass, roll call.
Representative Henderson. Representative Larson.
No.
Representative Sherwood.
No.
Representative Stith.
No.
Representative Walters.
Aye.
Representative Swanitzer. Chairman Nicholas.
So it's, I think we need to further explain the vote. A no means, I don't know, does everyone know what a no means or an aye means? An aye means it does not pass, right? A no means no to do not pass, correct?
Which then allows what? Mr. Chairman.
That means that we're not done with the bill yet.
Okay.
Is that, no, that's my understanding. Is that right, Tom?
But that status of anything, it's just cast however it falls. But I don't know.
No, my point is that
Right.
I just want to know make sure everyone knows what I means, what you're voting for and what no votes for.
I supports a do not pass.
Right.
No supports is against a do not pass.
Okay, let's do that roll call again.
Okay.
I support the do not pass. And I support a do not pass. And no is against.
So if it's a no, it does not pass the committee. If you vote aye, it does not pass the committee. If the majority is no, then the committee does not. The bill dies in this committee. You vote aye. Okay,
Ready?
go ahead.
Representative Henderson. Representative Larson.
Aye.
Representative Sherwood. Representative Stith. Representative Walters.
Aye.
Representative Swanitzer. Chairman Nicholas.
Aye. So that's 4 ayes, 3 noes, is that correct?
4 ayes for do not pass.
Okay, next bill. Go ahead. It did not pass. Correct. Yeah. Do not pass. Correct. It always has to come out of the committee if we do something. $250. All right. Representative Jennings.
Mr. Chairman, could I ask the first question? You have a substitute bill for this? Don't want to waste everyone's time.
We do not.
Okay. Go ahead.
Go ahead.
Okay, so Mr. Chairman, this bill is about due process and people's concern. So this bill is about due process. People's concern from the national push of towards red flag laws. And so this is a constituency type thing of where we're trying to answer that and quell people's fears. And it is along the same lines as the SEPA bill from last year. The first couple of pages gives the legislative intent and kind of, what we're trying to do with this. The real meat, seeing as how we're late in the day, is really on page 5. And the thing that we've tried to do in a collaborative effort with our sheriffs and law enforcement, along with the county attorneys, was that we didn't want to do, and I think that the secretary passed out an amendment that you did get that? Okay. And so as we were putting that forward in D, we brought that from the last year's SEPA bill so that it is nothing new to law enforcement. It's the same thing of if they step outside the color of law. And like I said, it was a collaborative effort between the sheriffs and police and the county attorneys. In section E, anything that the law enforcement can do now, they will still be able to do. The only thing that this would prohibit is if there's a push down from the federal side of this on red flag laws, where you could have a neighbor say he didn't like you or she didn't like you, and they could have law enforcement come and confiscate your weapons without due process. And so that's what this law does. In talking with the county attorneys and the sheriff's departments or law enforcement, they were not comfortable with E being completely clear. And so we ran this amendment by them and came to an agreement that it doesn't have anything to do when we say that on the front. Extreme risk protection is not the same as order of protection. So if you have someone that's suicidal or something where they have the obligation to go in and confiscate weapons, but it begins a due process. And so we're not trying to get rid of that. We're just trying to stop a federal push down. So I know it's late.
So Representative Jennings, And I just want to make sure and give this bill its fair due. Okay, and so I've read what I think, and I think I understand what the red flag laws are doing, and but would like you to just tell me in a brief manner, you know, my understanding is that they can come in and really based on mental capacity or concern, say that you can't have guns in your possession or in your, and and if I'm wrong, clean me up, and then please just say then how this bill prevents that we'll call abuse from happening.
I think, Mr. Chairman,
Go ahead, please.
I think the red flag aspect of this is not so much like if you were to be called for suicide, somebody really having a concern of mental incapacity or a danger to themselves or to others. This is more to the what we term as extreme risk protection. This would be, say, your neighbor came along and said, you know, I don't like the way Representative Larson cuts his yard, and I'm going to teach him a lesson. I'd like you guys, I think he's dangerous. I want you to go take his weapons. And what we're trying to do is stop that aspect of it. We want it to be adjudicated.
Can I
Yes, sir.
interrupt you there because I just want to track with you? So how can they possibly, is there something out there that we don't have within the state now that could come into play that allows that to happen? Because right now I'm saying, well, he can't do that if we're telling him to smoke someplace else.
Mr. Chairman?
Go ahead.
Yeah, so that is this bill being preemptive. The federal red flag law aspect would permit that, which is currently not available in Wyoming. But the national, this administration has put forward the concept that they would like to see that happen in all 50 states.
And is it a federal, it's not a federal law. Is it a federal law? Just try, forgive me.
Mr. Chairman?
Go ahead.
It is an attempt. There have been, the federal attempt is to basically bribe the states into passing that sort of legislation.
Mr. Chairman, following
ahead.
up on that, how do they bribe the states? Yes, I'm not tracking.
Well, Mr. Chairman, the current administration has put out that they would like and perhaps send some money to the states that do adopt that type of legislation. I suppose grants or, you know, that, whatever the federal
Mr.
way of
Chairman.
doing that. And I think there's some other testimony that will touch on that even more.
Representative Jennings, so was it part of the Federal Reconciliation Budget Act that passed in December of 2022 to provide money to encourage states to adopt red
Yes.
flags laws? Is that what you're referring
That,
to?
Mr. Chairman? Yes, Representative Stiff, that is the type of.
So, Mr. Chairman, so Representative Jennings, do you believe that there's a risk that the state of Wyoming will adopt such a red flag law in the future?
Mr. Chairman?
Go ahead.
So Representative Stiff, there does seem to be a bit of a propensity towards federal money. I don't think it's a huge risk, but I think our constituency out there believes that it is a risk. I guess in reference to like the SEPA law, you know, it's not a huge risk, but it's something that our constituency has a concern about. And we have seen federal overreach. Do I think that Wyoming will run to this? Probably not, but you know, I would point us back to the last 2 to 3 years. We have taken lots of federal dollars And so is it out of the question? Probably not.
Any other questions? Go ahead, Representative Henderson.
Thank you, Mr. Chairman. Just to take the moment to make sure we have clarity. We know about the federal preemption. How does this prevent that?
Mr. Chairman, I probably have better testimony coming behind me, but I think it would make it like stepping outside of the color of law if we were to do that, if this was in place. It would prohibit the implementation of and it's late. Been losing a lot of battles today, Representative. Could you ask the question again, Representative?
Mr. Chairman, I think we're all a bit punchy. Representative Jennings, I believe his question, Representative Henderson's question was, how would this bill make any difference if there were a federal law, rule, or regulation that were in substance a red flag law from the federal government? I think that was the substance of his question.
Oh, okay. Mr. Chairman.
Mhm.
Okay, so if there were a federal law, I think that that would probably have to be adjudicated out and as to whether or not it was constitutional or not. And this particular law, just like all of our state laws, could be subject to it. But this would certainly encourage the state not to sign up for that.
What this law does is say Wyoming and political subdivisions, everybody that's here are prohibited from implementing any kind of red flag type of order. That's it's kind of this point in time that that's moving forward. Would it be fair to say that if for some reason there was Congress passed, that's for that extreme, say Congress passed something, then we have to come back and revisit the whole thing. But for right now, until we can thwart any of that just by saying this is our policy in Wyoming, that type of orders cannot be emphasized. Is that right?
Mr. Chairman, basically, yes. Under the 10th Amendment, we're exerting our state's right.
Mr. Chairman,
Go ahead.
thank you.
Representative Watson.
Representative Jennings on page 5, section D. Could you just put that in common person's language so I understand? It appears to me,
Which section?
page 5 and then D. It's right in the middle. Basically says any a public officer as defined or whatever could be guilty of a misdemeanor and imprisoned and $2,000 fine. So exactly which people are those? I know it by definition what public officer is, but
Mr. Chairman, so section D was pulled out of the SAPA law from last year, which was taken directly out of the Wyoming Firearms Freedom Act. And it is the law enforcement officer or any public officer. It could be a mayor. It could be anyone who knowingly violates or steps outside of the color of this law could face those fines and time taken directly from our current law.
thank you.
Go ahead.
Thank you, Mr. Chairman. So again, just for clarity, looking back to the SAPA that we enacted, how does this differ from that? And I mean, how did we come to need this? Given that we have the SAPA in place.
Mr. Chairman. Okay, the SAPA would cover a lot of things. This would cover more directly to the red flag notion of that someone could come along and just make an accusation. And I think you could make the argument that a prosecutor could, or prosecution could be done possibly under either one. This just states it directly to this one issue, the red flag laws.
So let me see if I understand this. I'm on page 4. And I'm looking at the definition of extreme risk protection order. So the definition of an extreme risk protection order is any executive order, written order from a court, or a warrant from a court, which the primary purpose of that warrant is to reduce the risk of firearm-related injury or death due to one or more of the following, right? And so that means that the court cannot prohibit a person from possessing a firearm to reduce the risk of injury of someone else, right? That's what it reads to me. So come on up. Phone your friend.
Phone a friend.
I think I can answer a lot of questions that have been asked. I'm sorry, we've had 2 of our attorneys review this document. It's nearly identical to the law in Oklahoma and West Virginia. It doesn't prohibit anything currently going on in the state of Wyoming. That is made clear in section E on page 5. So an officer can still go and take a weapon from a person who's had due process, who there's a reason under existing Wyoming law to take that weapon. They can still do that. This is written to stop an extreme risk protection order. That is a civil process. And the way the federal government hooks the states is with money. That question was asked earlier. The money is already available. Theoretically, Jackson or Johnson County or some entity in Wyoming could get that federal money right now and implement extreme risk protection orders. This just prohibits that. But this does not in any way prohibit the law enforcement officials from doing the things they're currently doing under Wyoming law.
So you need to show me the language that says that, because what I just read does not say what you just told me.
Under nothing in this act. Yeah, I understand, but under E, bottom of page 5, nothing in this act shall be construed to preclude or limit the powers and authority of a peace officer as defined in Wyoming statute 7-2-101 AIV under existing Wyoming law before the effective date of this act.
Mr. Chairman.
Go ahead.
So, sir, I guess I'm following your logic on page 5, subsection E, up until line 20 at the end of the word. If it stopped at the word act, then what you're saying would make a lot of sense, because this would be saying nothing would limit the powers or authority of a peace officer under existing law before the effective date of this act, period.
Okay. Yes, sir.
That would get where you're going. But then you've got this phrase, or the bill, I should say, has this phrase afterwards as it says, except for the powers and authorities that conflict with the provisions of this act, which seems to take it all away again and say that this paragraph doesn't mean anything at all. I mean, let me ask it a different way. Would you regard it as a friendly amendment to put a period on line 20 after the word act?
I believe so, Representative, Mr. Chairman.
Oh, I apologize. And then you have a proposed amendment that deletes that paragraph and replaces it with something different. I
Oh,
apologize.
I'm sorry. And I thought that had already been put in. Sorry. This was, I should point out, this other E says much the same thing. This was written after extensive consultation with the Sheriff's Association and the county attorneys. And this amendment says nothing in this act shall affect the issuance of an order of protection under Wyoming statute 7-3-506 through 7-3-512. And you guys can read this. I don't need to read it to you. These are all the existing orders we could find in Wyoming, including involuntary hospitalization of mentally ill persons. So this right here is more specific to your comment, Representative, that allows all the existing Wyoming orders to be enforced after this act would pass.
Mr. Chairman, so if I understand it right, as initially drafted, judges would not have been allowed to issue domestic violence orders of protection or stalking orders of protection. But this proposed amendment creates the exception for that, if I understand.
And that wasn't the
correct.
intent but yes, there was some concern. The intent all along was to write this to allow judges to, and law enforcement to continue to do all the things they've already done in the past. And if that did not do that, it was an oversight. And we worked with the sheriffs and Representative Jennings to get the language here in the amendment to make sure law enforcement judges had the full tools available.
Mr. Chairman, sir, would you regard it as a friendly amendment to this proposed amendment to include also conditions of release upon bond? Because it seems like one of the really standard things for judges to do when someone's in jail, they want to get out. They say you post this much bail. And by the way, don't consume alcohol, don't go to the bars, and don't possess firearms. Sometimes the orders say that, sometimes they don't.
And that's a common practice, Chairman, a common practice under Wyoming law. We would have assumed that was covered, but yes. And nothing in this, I want to make clear, is intended to stop the practices that are going on now.
So that's one of the problems I have, number one. So there's lots of court orders out there say that are outside, I believe, of 7-3-506 through 7-3-512, where a court may find, for whatever reason, based upon the facts of the case, that a person shouldn't have his firearm.
May I ask a question, Mr. Chairman?
Please.
Does that person have an opportunity to have due process and defend themselves in those cases?
So the answer is he's already in front of the court.
Okay, so then that's not what an extreme arrest protection order is. It is an order that's issued without due process. I'm offended by your political views. I go to the sheriff and I say, Representative Nicholas has firearms. They come and get your guns and presume you're guilty before you prove yourself innocent without you having due process. That's what an extreme risk protection order is.
But yeah, but you can't do that in Wyoming now.
Well, theoretically, the money is available, not theoretically, the money is available. The federal government has made it available. There was a huge national story about it, and entities could go out. That's why this law prohibits local, it makes clear that the authority with that lies with the legislature. Local authorities could theoretically get that money and do that right now.
And I'm slow on the uptake. So where I think I'm getting hung up on that, Mr. Chairman, is if the local jurisdiction done that, they would be in they took the bribe, they took the carrot, but they'd be in conflict with state law. I don't think they could do that.
May I?
Looking at my two attorney friends, is that not right?
Mr. Chairman, it would take further action of the legislature, I would think, to impose a red flag law, right?
Well, yes, that a county or a municipality couldn't impose this law without being in conflict with state law. Yes, or I mean,
I don't know.
So tell me what you're talking about when you say there's money out there to do something.
The federal government made a huge news splash in June of 2022 with a federal program of, I don't remember how many hundreds of millions of dollars is available to the states to implement red flag or what they call extreme risk protection orders, what we call red flags. And to the question about how this relates to SEPA, and this was a point
So before you go on,
yes, sir.
how do you get the money? You have a copy of the act or the money or?
Well, it was federal law that passed in June of 2020. It was 2022. Community Violence Protection Program or something like that. You know, they always give these things nice names. And
The purpose of the act is to do what?
well, the purpose of the act in the spin from the Biden administration was to reduce gun violence. But, you know, as I was going to testify in my regular public testimony, there's no evidence that red flag gun confiscation orders reduce gun violence. What they do is they deprive people of due process. That's really what we're talking about. You're guilty until proven innocent. That's what
So my point, what I'm asking for is we need to see the law that you're talking about.
the federal law.
Yeah.
Yeah, well, it's in federal US code. I don't have that in front of me. Maybe some of our friends in the back here can find it while we're chatting. And
so I'm trying to look, give me the key words. I've got my computer. here.
look at June 2022 Biden gun control.
Peppermint. Is this the public law?
So
Extreme Risk Protection Order Act to establish a national red flag law.
and see, they don't make you enforce it in Wyoming. They bribe you with money, as they do many other things, right?
So this was something that just passed the House. It hasn't been acted in.
No, it was passed. If you're not looking at the right one, it passed in June. Mr. Chairman, it passed in June of 2022.
So look at House Resolution 2377, Federal Extreme Risk Protection Order Act.
House what?
HR, H period, R period, 2377. That should probably be enough.
Dash what?
Federal
Yeah,
Extreme
but what's the numbers?
2377.
Mr. Chairman.
Individuals who pose a threat to themselves or others from possessing a gun. So I'm curious, are there specific? What's the specific language of the act? So that we need to know.
Do you want definitions or? HR 2377, an act to authorize issuance of extreme risk protection orders being enacted by the Senate and the House. Short title, Federal Extreme Protection Order.
So let me back up a little bit. I mean, I don't mind, I don't want government overreach. Part of the problems I have with this bill is, number one, the declaration of authority. I mean, if we want to pass a law, let's pass a law, but let's not, to me, we don't have to go through the constitutional sites and as if that's the sole basis for it. If we're infringing on it, on our individual rights to have guns, that's fine. And so I'm not, I don't like the findings of it, but what's more important, then you go to the definition of extreme risk and protection order. What I don't know how we can find out in a reasonable amount of time is what other instances there can be other than 7-3506 through 73512, when a court may enter some type of order regarding firearms, that is not addressed, because you provide, do you understand what I'm saying is that there could be other situations. When you limit it to just that situation, that means everything else that the court do would be basically, he would be committing a crime by doing it. So you could essentially, then you would have a court of law essentially committing a crime and subject to a year in jail, or however the warrant is issued. So that without having a bunch of research on it, we don't know the answer to that. But I know that there are other instances outside of 7.3 of the criminal code, and of that section, where on a regular, at least on some basis, protection orders are issued. So that's what I don't know. And then the other question is, what in our current laws are, does the federal law, what the differences are? So that's just a lot of different issues, but go ahead, Mark.
Mr. Chairman?
Yeah, go ahead.
Mr. Chairman, as I've looked this up, and I would sure love it if you could correct me, but what I see is that this passed the House on
June 7th.
6/7 and was received by the Senate on June 9th. But I am unable to find where it ever passed the Senate. And I just may not be finding it in my quick search.
Go ahead.
Mr. Chairman, so I believe it's the Bipartisan Safer Communities Act became public law number 117-159 on June 25th of 2022. What it does is it amends the so-called burn grants in section, I had it here just a moment ago. States can apply for grants, and they created a new category for grants from the federal government for states that adopt programs that include extreme risk protection orders. So it is federal law. There is money out there. A state could say, oh, you're going to give us money, we'll adopt a law to implement essentially a red flag law, right? Obviously, that has not yet happened in Wyoming yet. So this bill, frankly, is a bit early, right? Because it's sort of saying we don't want the state of Wyoming to ever adopt one of those. What I don't know, just from reading this, is whether municipalities can even be applicants for burn grants. I don't know that, which is kind of a big deal, because if only states can be applicants for these burn grants, then the bill wouldn't really do much, because the legislature could always apply for a grant and amend this, even if this were enacted into law. So sorry that's the extent of my 5 minutes of legal research. I apologize.
Someplace there ought to be a summary and an analysis of this. Have you seen anything like that? I mean, I'd just like to see a breakdown and how it's been implemented and who's applying for it and what the.
Well, Mr. Chairman, a number of blue states immediately applied for the money, in New York, Illinois, places like that. And one of the things about this bill that I think is good is that if you understand our existing Second Amendment Protection Act, which passed in March of 2022, that's where the penalty that one of the representatives asked about earlier comes from. It's already in statute. That law is broad, and it says that law enforcement or officials will not enforce unconstitutional actions. And one of the big questions in everybody's mind through that whole battle, and even now, is what's unconstitutional. And this law helps clarify one of the things that would be disallowed in Wyoming would be taking this red flag money and implementing these orders. And I think that's maybe why you don't see law enforcement here screaming and yelling about this thing. We talked with them for hours and asked for their input. And I would be surprised if the orders they need to enforce are not found in those statutes, because we begged for comments and this is all we got, that they needed to continue to enforce the laws they were enforcing. So what I would tell you is we have bent over backwards, tried very hard to let law enforcement have all the tools they currently have and just stop this federal overreach from ever finding its way into Wyoming.
Go ahead. Representative, go ahead.
One of the other things that I wanted to answer, Mr. Chairman, that I think in my mind in working on this, we wanted to be very narrow tailored, and things like the judge case and things of that. If they were able to do that now, which they are, we're not touching that. We don't want to touch that. We want to leave that aspect alone. We only want to touch the aspect of, if at some point in the future they were to be enticed to sign up for that.
Well, and, I would, that may be the case, but to me, it's just from being a practicing lawyer, I know that that happens a lot more than just your currently cited statutes. And so that's my question is, how do we make sure between now and when and if this bill gets kicked out, that it does just what you said, and it allows the courts to do what they are doing now
Mr. Chairman?
without restriction?
Obviously, I'm a public person testifying for a national group and I live here, but we've had two attorneys. One has worked on Second Amendment cases for 50 years. He was involved he worked for Reagan in the 80s. He's still involved. The other's a younger attorney. Two attorneys have gone over this with a fine tooth comb.
Are they attorneys in Wyoming?
Well, no, sir, but they're national attorneys that work on Second Amendment issues. And this law is very similar to the law of Oklahoma and West Virginia. Just giving you some data points here. I understand you have concerns. Very, very similar to the laws of those states. The Oklahoma law has been in place for 3 years now. And again, I would say that we diligently tried to work with law enforcement for feedback, and they don't seem to think they would be here, I would think, if they thought this was going to restrict their abilities to do the things they've been doing.
Chairman?
Go ahead.
Mr. Chairman, as I read a quick summary here of this, I've heard a comment about this due process and things. All this federal order is basically what I read is a federal version of our Title 25. Certain individuals have to, if there's a concern that they pose a risk to themselves or others, then the law enforcement or the family members petitions a court to take these actions. I've heard it the way it's been described is municipality says we're going to have a red flag law, and now the law enforcement can just go take everyone's guns. That's the way I feel like it's been described to me this evening. But the federal law seems to be very tailored to, like I said, to our Title 25 laws, where somebody poses a risk that's believed they pose a risk to themselves or others, and then they petition a court and action is taken based on what the court sees as the evidence. Is that person a risk to themselves or others? And that, again, this is a 5-minute search of what this federal law that you have now brought to light is. So I certainly haven't read all however many pages it is. I'm just reading the synopsis of it. And so that's what I'm trying to understand, because early in your testimony, Representative Jennings, you kept discussing due process and this happening without due process. But if to ever allow this to happen, and then you have to petition the court to even allow this to start the process. To me, there's due process from the beginning. So I'm struggling to understand where this goes. And this is a question for Representative Jennings. Thank you.
Well, I think it's mostly like I said, preemptive to stop that from becoming something that would become less of a due process scenario. And I do not have what you're asking for, that I've not read through the federal aspect of this. Like I said before, this is kind of constituency driven, that people in Wyoming public, your constituents and mine, are concerned about this, that this goes to a place of not getting due process, the same as Title 25. Title 25, I think, does give us due process. And this coming down from the feds, and like I said, I can't prove this. I'm just relating what constituencies have said to me.
Representative Jennings, I concede, I received concerns from my constituents about this. And, to this point, it says we just don't have red flag laws in the state. There seems to be concern that there's a threat of those being adopted or somehow going in. So I don't argue that. I just want to make sure that whatever we do, that we've got it right. And so then a question that just in your conversation, it says that this prevents the state or other entities from receiving any of this funding, but I don't see that. Now, it says that you can't use any money appropriated by the legislature or of any other source originated outside the state of Wyoming area to implement these laws. Right. But it doesn't prohibit you from receiving the money. Now, you could receive, and I guess my point there is we can receive, unless you're saying that the only thing you can do with that money is implement.
That's what, the federal government will require that if you take it, that you implement it. And so we're going to prohibit it from being taken so it can't be implemented.
Well, and so to refine that just a little bit more, so it's really not that beneficial to me as a county or a town if it's solely just implement. I mean, okay, I'll do what you want, but I also want to go to the movie too. But what you're saying is that the money can only and solely be used to implement and enforce, to implement law, provide training, to do all of those things that would enforce red flag laws.
Mr. Chairman and Representative, yes. Well, and it specifically prohibits the use of personnel. And see, that's the way the federal government tries to implement gun control. And this is what a lot of folks don't understand. Federal gun control on a massive scale will not happen by the ATF or the FBI. It will happen with the use of local law enforcement. I mean, that's what happens in blue states. And we're not telling the feds they can't do something. We're telling the feds they can't use state personnel and state personnel can't use federal money. And that pretty much takes the sheriffs and the police chiefs out of the red flag business in Wyoming. It's a very common practice that's done under 10th Amendment principles to stop federal gun control. When a lot of states have done it. That's what our SAPA does. It doesn't stop the ATF from coming to my house if they think I've broken a law, but it stops my sheriff from coming and enforcing an unconstitutional action. And that's what this does.
Let's stop there. They're not unconstitutional actions. They may be in your interpretation, but not in the U.S. Supreme Court's interpretation. And so, to me, I think we have to be careful in the terms we use to be accurate versus subjective on what our beliefs are. It may be that you sincerely believe that, but we know what the laws are right now. If you're a lawyer, you read them, we know what is constitutional, what isn't, and what restrictions they can have on firearms. So I don't want to go down that road. But if this is the right thing to do for Wyoming citizens, to protect them from some type of abusive conduct, overreach of some sort on our personal rights that we believe in. But to me, it's not a constitutional question. It's how we want to live our lives. But I still don't understand what exactly this does with the language here in terms of how it impacts the courts and our actions, because it's just not. I just don't think this has been worked down to that type of, that type of degree. And, but, I mean, I'll work on it over the weekend, but I'm not sure how to get there with what we have. To where you want to go.
Mr. Chairman,
Go ahead.
follow up. So I just feel like I'm not very, so help me on the personnel thing. So it says, you know, you brought that up and I didn't catch that, but we can't use any personnel, the state of Wyoming or any of the political subdivisions can't use personnel to implement any statute, rule, or executive order. Is that a federal statute? Because it
No.
doesn't say a federal statute.
No, sir, that would be state.
It's state?
Yes, I mean, there's nothing in this
So-
bill that would pretend to preempt.
Well,
federal
but
law.
so you're saying they can't use their. Is this law enforcement personnel?
It would be any political subdivision of the state would not be able to implement extreme risk protection orders.
Well, okay, but but it would be law enforcement.
Yeah, that's who's going to
Right.
enforce them. Yeah,
But if it was state law, you'd be able to use.
sure. If this passes and you come back and pass a different state law, then you preempt this. But
I'm trying to make this work, but I just keep, some of the pieces just don't fit because it doesn't make sense to have the personnel in there because the personnel, you're saying that the personnel, the law enforcement people can't implement any rule, executive order enforcing the extreme protection order. Well, they can't implement anything that's not a law anyway,
well,
right? Am I missing?
yeah, the one thing maybe we're missing here is that an extreme risk protection order is a civil order. It's not a criminal order. And in fact, we had 4 words that we were prepared to offer as an amendment. I thought that the Sheriff's Association was going to be here because they had raised the question and then they kind of dropped it. But we could insert, let me pull it up. If you go to,
So where does it say that this is only civil and not? I mean,
well, that's,
your definition doesn't say.
and that's why we were going to suggest on, let me get the exact right spot. If you'll bear with me, I got it right here.
Go ahead.
Okay. Under I.
Look, excuse me, Mr. Chairman, Reed Representative Jennings, you know, we worked pretty hard on the Second Amendment Protection Act. We all did. And my concern is that does this potentially preempt what we worked so hard on there? I mean, I think your organization supported what we did.
Sir, I think it clarifies it. I think that the SAPA is very broad and many people have said it was confusing. This clarifies one thing that's clearly not allowed under it. It's a stepping stone. It's an incremental approach. It's, you know, we passed SAPA, we made unconstitutional actions illegal. We provided a penalty of up to a year in jail. We collectively, the legislature, and this clarifies one of the things under it that might be confusing. So I think it complements SAPA. That was the intent of it. And
Mr. Chairman,
to,
Mr. Chairman,
sir,
Mr. Chairman,
Go ahead.
with respect, you're gonna have to show me that because I don't read it that way based on my understanding, recollection of the SAPA. I mean, I get the paragraph that we brought over and maybe that's needed in here. I'm not sure because I haven't read this act that we just referred to earlier. But I want to be reassured that we're not going to be doing any damage to the good work we did on the, you know, remember, Representative?
I agree, Mr. Chairman. I agree that we don't want to harm that, but this is narrowly tailored to this one specific thing where SAPA was more broad reaching. A lot more things. And another aspect of that, I think it was mentioned about the people. in my community, they're debating extreme orders. Let's see, I'm trying to remember what they call them. And so that if you had some sort of emergency, they would essentially just say the dog catcher could go out and write a ticket, stay in your home. I don't know that it'll pass. I hope it doesn't. But that's the type of thing that I think reaching in for the people, the personnel, it's saying that, not, so it doesn't touch just law enforcement. It would touch. There you go. Thank you, Mr. Chairman. And yes.
Mr. Chairman, I have the language that addressed the question about the civil. If you go to page 4, at the top of the page, section I, where extreme risk protection order is defined, if after the word means you insert a civil order, comma, including, so 4 words, that clarifies further the intent of this to address these extreme risk protection orders that happen without due process and not impact any of the criminal processes that are currently available. And one of the representatives said earlier, they didn't see where these didn't involve due process. There are many cases in America where people have been killed when extreme risk protection orders were enforced without their knowledge. What happens with an extreme risk protection order in some of the blue states is they're issued without the knowledge of the person. Give you an example. There was a man in Maryland, 60 years old, never committed a crime. Police showed up at 5 o'clock in the morning to take his guns away. He had never been informed that there was a complaint against him. Well, he went to the door with a gun. If you come to my house in Johnson County, Wyoming at 5 a.m. in the morning, I'm probably going to the door with a gun too. He went to the door with a gun and he was killed. What was found out later is the complaint was made by someone who disagreed with his political views. He happened to be an African-American. I don't know if he was conservative or liberal. Someone disagreed with his political views. They made a complaint. And when the order was enforced, he was killed. Never committed a crime in his life. There was another case in Vermont where some teenage boys were talking about doing some stupid stuff in the school. Someone got an order against the uncle because the uncle was known to have firearms. And they went to the uncle's house without his knowledge, without due process, took his firearms away. In many cases, there have been a lot of people killed in these execution of these orders. And there have been a lot of cases where people that were completely innocent, never convicted of a crime, didn't get their guns back for years and spent tens of thousands of dollars in legal fees. That's the kind of thing this is designed to stop. And if we add that language about the civil order part there, and I think with E, the amendment that Representative Jennings brought forward that we discussed extensively with law enforcement, we're trying to make it really clear that all the existing things they can do in Wyoming are allowed.
So I don't see anything in this that says without due process of law. It's not even in here. And yet that's what you're saying you're trying to protect.
I believe it's in the definitions.
In your definition of extreme risk.
Oh, yeah, it's in the preamble and that's just a style.
Part of the law.
Okay.
So literally, there is nothing in here that says that an extreme protection order is an order that is done without due process of law. It's not what this says. So I guess what I'm really saying is that I just don't think this thing is ready for prime time. I really don't. And so I'm just trying to figure out how you can get it there. Okay. Any public comment? Any public comment? Welcome. Sorry that you got to be here at 8:15.
It's all right. Probably all the people, other people were wanting to be here, couldn't get in the building. It's locked. And I just
You got to
happened,
open the doors.
no, I just happened to be coming in when somebody
Oh,
used their key card to
you
let
should have
me.
just put your shoe in the.
Yeah, I
Get
don't
off.
know. I know my husband's out in the car. But anyway, so I am still Beth Howard and a longtime resident of Cheyenne, and Chair Nicholas and committee. I thank you for the opportunity to speak. I believe that this is based on a false premise and it's a bad law. So I have to just encourage you. I looked up extreme risk protection order and I thank Representative Walters. It says what it says. It is a legal action. It doesn't happen without family or law enforcement or somebody going to the court. There may be hearsay, there may be stories, it may have happened at some time, but the law is the law. The existing law says that it is a civil action and not a criminal action, but a civil action, but it doesn't happen without going to the courts. So I just think it's dangerous. to Pass a law that's based on a false premise. And so thank you. I also think we really, based on domestic violence and suicide here, we need all the tools to be able, and I know that the amendment, which I didn't see, apparently keeps those tools in place for the purposes of suicide and domestic violence. And that's important to save lives in Wyoming. So thank you.
Thank you.
Any questions?
And for all the folks that you know that were wanting to come here, we apologize that that door was not open because
It's
they're not supposed to lock those doors when we're still having committee meetings.
okay.
So
That's fine. And
take care.
that's what the person who let me in said, that, oh, they locked you out? So anyway, thank you.
Okay.
Mr. Chairman, we
Go
do have online a Mr. Mark Moody.
Okay. Welcome, Mr. Moody.
Thank you, Mr. Chairman, members of the committee on this late Friday night. Mark Moody, resident of Cheyenne here in Laramie County. I support this bill 100%. These red flag laws are unconstitutional. They violate not only the Second Amendment, the Fourth Amendment, the Fifth Amendment. I mean, you name it. So this is a very good law because we know our neighborhood of South Colorado has it. It has been abused many times, especially in Denver. There's actually been municipalities like Weld County that borders us that will not enforce it. And law enforcement does not want to implement red flag laws. Oh, I know Sheriff Reams of Weld County said, I'm not doing this. I'd rather go to jail than enforce an unconstitutional red flag law. There's no due process. Essentially, that was said by, the great person that represents the gun organization. Your neighbor could say, oh, I think they're dangerous. And then you just bang on your door, pound it down, and then take all your firearms with no due process. And then I'll lead on this note. In the state of Maryland, there actually was a gentleman that had a red flag order there. He didn't know who it was. The law enforcement shot him dead. Again, that state has a red flag order. So I'll be happy to take any questions. Please vote aye on this bill.
Mr. Chairman. So Mr. Moody, I do have a question. I don't think that this committee is struggling with the intent of the law. What we're struggling with is the construction of the law as it is in this building or in this bill. And as we try to find out, we find out that there's some key components that are in the preamble which do not make it law. There's some undefined things. And so when we do this, for you as a citizen of the state, how important is it that we get the bill? I mean, is it important that we get the bill right? Or is it important that we just pass a bill?
I would say, thank you for the question, Representative Larson and Mr. Chair, members of the committee. I would say that, balance of both, but we definitely do need to get something passed because we know the current administration, they're very anti-gun. They are going to try to, again, they don't care at those federal dollars. So we definitely need to get something passed. I mean, it looks good overall. Just the amendments that Mr. Jones mentioned, I think they're perfect. And this would be really good. And I would say show that we are just like a gun-friendly state, kind of like the state of Oklahoma. Oklahoma had a very similar law and it's pretty good. I know it mirrors it there as I've seen it.
Appreciate your joining us tonight. Thank you.
Thank you very much.
Okay, any other public comment?
We've got some legislators here.
Any comments? Anyone that wants to? Of course you can. You can always make a comment, Pepper. And this committee, we're not quite so formal as other committees. So. We got too much going on so go ahead.
Thank you, Mr. Chairman and committee. I would just like to say that one of the concerns that I had with the movement of the red flag laws is the problem with having someone having their personal property taken and then having to go to court to get it back. So that is extreme and it's costly and it's a problem. And then as far as another comment, I would say a while back, probably a year and a half ago, I was watching some meetings on the computer and the Colorado was on, and there was a lot of representatives. There was firemen there, there were sheriffs there, there was police departments there, there was legislators there, and they were all talking. The law enforcement and different entities from county, state, and local all said, we don't need these. We don't need these. We have laws in place that protect the citizens, and so we don't need these special laws. And it would be very hard for us to enforce because they don't follow the jurisdictional things that we have right now. And so they gave this presentation. It was all very good. And then all of a sudden, the legislators voted it in, boom, like that. And so that is the thing, depending on the belief system of the people that are in office, oftentimes is very powerful, depending on what they are. And so as I watch the state to the south of us put those in, they are enforced, and it's going back and forth as far as if they're overreaching. But I would just say this conversation is very good, and I appreciate you guys trying to figure out a way to make it work. Any questions?
So I'd like to get the laws, the red flag laws that you were talking about and see samples of them. But I presume you've got a file someplace that we have. Yeah, go ahead. Go ahead, Bill.
Have something to use as a basis for making this work. I don't mean that. I mean the other side of it that we're
Yeah,
trying
the
to fight
laws
against.
that you're talking about, that they go in and violate.
They're not forcing you to do, they're throwing the money when they go out. And as Representative Bachman said, Colorado grabbed the money. And they're having a meeting there with Colorado, they're gonna have the sheriffs in Colorado that are enforcing. Law enforcement, and especially in rural America, does not want to enforce red flag laws.
Again, I don't think we're arguing with what we're trying to do. I don't think there's anybody on this committee that wants to in any way have the federal government come in and in the circumstances that we've heard today do this. I'm just trying to figure out the right way to do it. I'm struggling. I thought I was really close. In fact, I asked the chairman, why can't we pass this? And then as we kept having the conversation, I'm finding some pieces here. And it reminds me of, I think, my third or fourth year when in the Minerals Committee, it was so important that we passed this Class 6 injection well law because of a company that was getting ready to do some enhanced oil recovery, and the Class 6 injection well laws conflicted with that. And we come within a gnat's whisker of having the Oil and Gas Commission governing the Department of Environmental Quality. And then telling them, and when we went and talked to those two directors, they said, listen, we tried to explain, you guys go do what you want to do. And, we'll make it, but it doesn't work. We finally got it. Tom was on that committee. We finally got it. I just want to make sure, into the good chairman's point, we get that it's on the civil side, but it's not in the bill. It might be in the preamble. But, if we can do that, and there's just, and how we use personnel. I'm struggling to find some of those key components, and I'm just wondering if we don't need to get that fixed.
Go ahead, Mark.
Mr. Chairman, Representative. So I think what you're possibly talking about is an amendment that might put in something there without due process, because that is the goal here. And, if we whittled the preamble down, I don't think that's anything, but I think, the meat of the bill is there in the back. It's 4, 5, E. And then so.
So another question, one of the things you do in this, I mean, it's interesting because you're saying there may be laws coming down. But you're saying, in essence, a county can't pass an ordinance, or a local government can't do anything which would violate this act. So it preempts those actions.
Which is your authority, sir, as the legislature.
Well, except that we don't pass laws that prevent other people from passing laws. That's not typically what we do. We pass laws that have specific purpose. But let's give you another example then. What you're saying, so if a judge gives a court order that violates this, and he gives that court order to a law enforcement officer, and the law enforcer tries to enforce it, but he has to, because he's an officer of the court, so he has to enforce that order. Law enforcement officers don't know what an extreme risk protection order is. That's not what their job is. Their job is to enforce the order of the court. And so that means that he has to violate his duty as a court officer, even though he doesn't know it. But then he's subject to a misdemeanor, a fine of $2,000 in a year in jail because he enforced an order that may be a violation of this act. Is that what you intended?
No, sir, Mr. Chairman. This law would prohibit the judge from issuing the extreme risk protection order
So
without due process.
that's not, well,
You would have to use existing statutes as defined in Section E of the document that exist before, and there's plenty of them there. We're not having an outcry for more laws related to this. The judge would use one of those, but he would not issue one of these red flags like happened in Maryland, where the gentleman was killed at the door because he never knew he was accused of a crime. There's where the due process comes in.
well, I see what you mean. That doesn't mean that the law enforcement officer knows that the judge didn't. The judge didn't. The judge, the ones that you're saying, the judge probably should go to jail for issuing an order that's.
Well, I think our judges, Mr. Chairman, judges would understand this. I mean, this law is in existence in other states, and the judge would understand this, and he or she would use an existing criminal process that's covered in Wyoming statutes. He wouldn't issue an extreme risk protection order.
So, what you're really saying, I think, is before a court can issue any type of a warrant. It's not even a warrant. It's an order to remove someone's weapons from their home for whatever reason. He can't do it without due process. In other
Yes,
words, you got to give you got to give notice and an opportunity to be heard.
Yes.
That's not what this says. And it'd be really easy to write what I just said into a law. Pretty simple. And in fact, we kind of have that law already. The only time you can go in and take a gun is if the court finds there is a immediate risk of injury to a person, place. And if that is not the case and an order is issued, that's when you have $20 million lawsuits against the law enforcement who are enforcing it. You know, there's numerous instances of that you read about in the press now, and then, because that is against the law. And they weren't properly executed, and law enforcement didn't properly execute. But it's 8:30, and so we need to come to a conclusion on how we're gonna handle this. I mean, I'd love to work on this and write amendments, but this thing needs to leave this committee in one fashion or another tonight. Because and I'm sorry that this showed up this late and how this thing evolved. But one way or another, I mean, this issue isn't gonna go away. This bill and the content, the philosophy is not gonna go away, so. All right. Gentlemen, any other public comment? We'll close public comment. We have a motion on the bill.
Mr. Chairman,
Go ahead.
I move the bill do pass.
There's a motion to pass for the bill to do pass. Question? Go ahead.
Chairman,
Discussion.
I would move an amendment to adopt on page 5, lines 17 through 22, the proposed amendment as presented, however, adding the phrase at the end of that proposed amendment, or court-ordered conditions of release on bond.
Moved and seconded. Jackie, did you hear that?
Yes,
Okay.
I did.
Does everyone hear the amendment? All those in favor say aye. Aye. Those opposed? That motion carries. Go ahead.
Mr. Chairman, I would move on page 5, lines 11 through 15 to delete those lines.
Is there a second? All those in favor say aye.
Aye.
That motion passes. Any
So-
other amendments? Go ahead.
Mr. Chairman, I think it's on page 6. I'd like to change it from immediately effective to June 30th. As confusing as it sounds, if it passes effective immediately, it sounds like there's some problems with it. So July 1 is what I meant. Yeah, eyes closed.
All those in favor say aye. Aye. Those opposed, that motion carries. So, committee, I would make an amendment to strike page 2, lines 8 through 23, and page 3, 1 through 18. That's the preamble. Discussion? All those in favor say aye.
Aye.
Motion carries. So I would also make an amendment to insert, I need to find the right place for it. It would be line F on line 4 after court. Page 4. Line 4. So it would read, written order or warrant issued by a court or signed by a magistrate or other officer of the court without notice and or without prior due process or notice of law, basically is what I'm trying to say. And that's the whole point of the bill, basically.
Mr. Chairman, if you wanted to achieve that, you could use the phrase on line 2. You could say, instead of means and, you could say means any ex parte,
Yeah, I think that's, yeah.
because ex parte
I think that-
connotes that the court does something
there is
to
no
you
notice.
without giving notice to the
Right.
person affected.
Okay, did you get that?
That one I'll need a little help on.
Okay.
I believe it makes the most sense, page 4, line 2, at the end of that line. It means,
And
any ex parte executive order, written order.
It means without notice. That makes it make a lot more sense. Okay, all those in favor of that motion, say aye. Aye. Those opposed, that motion carries. Any other amendments? Okay, as amended, roll call.
Representative Henderson. Representative Larson. Representative Sherwood. Representative Stith. Representative Walters. Representative Swanitzer.
No.
Chairman Nicholas.
No. Okay. We'll keep working on this. Which one? I'm not. Each one on.
Are we done?
No, wait.
Okay.
We've got that. We had one for 160.
No, we're not gonna do that. The first way we do it is by not. Yep. Yep, we're done.